Paul.
Quite a few business entities have weighed in on the faster labor contracts bill. I have a list of 29 associations, including packaging, chemical distribution, hotel and lodging, pipeline contractors, truckers, builders, contractors, a whole host of associations. And I'd like to ask unanimous consent that these organizations that are opposed to the Faster Labor Contracts Act be entered into the record.
Without objection.
I also have a list of 45 different business association groups opposed to the Warehouse Workers Act, and I would ask unanimous consent that those be entered into the record.
Without objection.
Ms. Greszler, can you give us an idea of how right-to-work states compare with non-right-to-work states, business formation, economic growth, unemployment, things like that?
Yeah, so over the past 50 years or so, we've seen about 2 times the employment growth and 3 times the population growth in these right-to-work states, and that's because they attract more businesses because they have the certainty of knowing that they will be able to set up their shop and not have a union come in and take control over their operations.
How do wages compare? Do you think the right-to-work states are just, are exploiting their labor and paying their workers less? How do workers' wages compare right-to-work, non-right-to-work states?
Yeah, thank you for asking that because that's often misunderstood. But when you actually do an apples-to-apples comparison of wages in right-to-work and non-right-to-work states, you see that when you account for the differences in costs of living, that workers in right-to-work states do just as well, if not better, as those in non-right-to-work states.
Yeah, I'm actually impressed as I go around Kentucky to very large international businesses that aren't unionized, how good their workers are doing and how happy their workers are with their job, as well as health care and the whole gamut of things. When we look at the Faster Labor Contracts Act, Ms. Greszler, you had mentioned that it impairs sort of some of the ability on both sides, really. Both labor and business could feel like their full ability to exact their leverage might be limited. Labor might have, over a longer period of time, the ability to strike. The owners might have the ability to let go workers trying to figure this out, the pressure both ways. So it takes some of that give and take away, and it will be replaced, instead of by labor and business, it'll be replaced by then some bureaucrat who's not involved in this.
Yeah, and I think that's really important that it affects both sides of the issue here. And when you have a first contract, especially if you have a company that has never been involved in negotiations or a union, that it's the first time that they're representing workers, they need to understand all of the issues at play, and they need to play those out and say, will this make my company uncompetitive? Might I have to shut down or lose jobs? And for the workers to consider all the different things that they might bargain over, what is most important to them, and what are the long-run implications, because that first contract sets the stage for decades more of future contracts. And when you look at some of these contracts that are out there, I looked at Ford's contract with the UAW in December of 2023. It's hundreds of pages, thousands if you include memorandums of agreement, and there are 313 items that are listed on the table of contents that they bargained over. So these are too many things for both workers and for employers to be able to consider within a time of 120 days.
Some have argued, such as Hayek, the road to serfdom came up earlier, but have argued that the right to contract really is a basic fundamental right upon which really the economy is based, the right to have certainty and to have honesty and have the courts uphold without an arbitrary nature, but to look at contracts from a dispassionate point of view. So getting involved in the middle of contracts, I think, shouldn't be done lightly, and considering the ramifications of what it does to the economy at large. The National Right to Work law basically just removes some aspects of federal law. It doesn't create new law. Then the way the National Labor Relations Act was written says that you can't discriminate against workers. And then they had to put an exemption in there, except for you can discriminate against non-union workers, basically. And so that exemption is what is removed by National Right to Work. What do you think would happen if we had national right to work? What would the general economic sort of scenario be, Ms. Greszler?
I think that it would improve the economy. We'd seen what's happened in the states that are right to work, but more importantly, it just preserves that fundamental right of every worker to be able to choose whether or not they are forced to pay a private entity as a condition of their employment, and that's just a fundamental protection that they should have.
Thank you.